This is for you. It's such a pleasure to know you, and the way I do. Let me explain. I know that our ride is new. You better not worry, 'cause all my words are true. I wanna thank you for stepping into my life.
Hi, everybody. Thank you so much for coming to this panel. It's the last one of the day, I believe. And you all pulled through. Congratulations. It's been a really fun and exciting 2 days of panels and discussions. And today we are going to really talk about trends in global surveillance. And we have 4 amazing panelists here to kind of really give you a flavor, a sense of developing trends in this area, how governments are seeking to collect, retain, share information of millions, billions of citizens worldwide. So I'm just going to leave it to the panelists to kind of introduce themselves and then segue into some of their key findings before we open it up for kind of more questions. So we keep this fairly informal and engaging, hopefully, so that people can, given that we have a reasonably small room, we can kind of maintain engagement between the audience and the panelists. So I think I'm going to start with Katiza, and Katiza is with EFF, and I'll let her take it away.
Hi, thank you, Amos. Well, my name is Cottage. I'm Peruvian, but I work on the Electronic Frontier Foundation here based in San Francisco, California. The idea of the panel today is we are going to share some of the preliminary findings of research that each of the organizations are doing on surveillance law. So in the case, I will present EFF work. We have been working in Latin America in 12 countries, assessing compliance of the national surveillance laws vis-a-vis the international human rights standards. And we use, for those who are the necessary and proportionate principles as a guideline. For those who are not familiar with the necessary and proportionate principles, they are a set of guidelines, plain letter, also the analysis they did in Central America. So we take all the research and we try to identify trends in the region. One of the most worrying trends was that actually Latin America is leading on data retention. We shouldn't be proud about it, but really it campaigns against that by civil society, including one of the biggest and largest protests on the streets in Germany. There have been quiet norms through the region, and I'm talking from Mexico to Argentina. And some of these laws, it's like from the 13 countries that we review, we have Mexico, Peru, Chile, Brazil, Paraguay, Colombia, Honduras, with mandatory data retention obligations that compel ISPs to retain metadata, who communicate with whom, for how long, for a certain period of time. And that's not the only worst thing that we found. We also found out that actually in the European Union, you have the 6 months to 2 years was the directive before it was declared invalid by the ECJ. In Honduras and Guatemala, it's 5 years. So the 2 years in the European Union is nothing compared to the obligations we found out in those countries. And so also a trend, it was no clear rule for access to the data, no clear rules for which data can be retained. Some of the laws are even vague, so vague that actually you are unsure whether it's just only subscriber information that they are requesting to retain, or it's just all the broad metadata, who communicate with whom, for how long, from where, or even if it's applied to internet companies. But that's not the only problem that we found on all these data retention laws. According to international human rights standards, the law has to be prescribed by law. It has to be a public norm, whether it's even the executive, but whether it's passed through parliament. It's very hard to monitor administrative law. We have the case in Brazil that some of the worst data retention mandates were in administrative law. So you have a lot of series of small laws that it was never in the public radar. And it's hard for civil society to find out that that little law, administrative law, exists. So that's one of the topics. And we assign compliance in each of the 13 principles, and I think I can write a thesis now, although I don't need to, but it's long. But so I choose to, for today, I have to be brief, just two principles. On the legality principle, well, we found many surveillance laws that are administrative, so they don't comply with the obligation of prescribed by law. But we also found a lot of laws that are very vague, and they have not clear information of the data that can be retained, of the who are the entities who have access to the data, or even worse, in Paraguay, for instance, there is one provision that is too broad and too vague that allows the use of any surveillance technology to be created that exists now or could be created in the future. So they can, no matter which kind, no matter if you're using INSI catchers or you're using malware, this provision already sees allow the use of any kind of surveillance technology to be created to now and the future by this provision. It's like a loophole. So you cannot discuss whether the standard for protect the data is right or not, is what it is, and you will not. It's very hard to call attention on Congress when it's supposed that the police will say, the authorities that I'm using to authorize the use of malware is already in the law, so I'm already kind of protected. So they have been very difficult to try to reform this legislation in that country and try to narrow these provisions. So there are precise rules for this different kind of surveillance measures. Then other things that we found was that we found a lot of secret rules or protocols. So for instance, telecommunication companies is secret, although they sign the contract in all the media is excellent, but nobody can read it. Currency, and that's Mexico. Mexico have passed obligations for companies and the state to adopt transparency reports. And the interesting thing is that the transparency reports, for instance, for the private sector, is not like here in the US that you have Google or Twitter issuing their own privacy reports, and probably it's very hard to compare each of them because they use different methodology. In Mexico, all the ISPs are issuing a transparency report through the ISP Chamber of Commerce, I don't know, then you who have all the ISPs together. They are combining all the data and presented a single number. And in addition, now with the transparency obligations, the state have also, it will become obliged to issue a transparency report. So you will be able to compare and see if there is some data missing or not. We also found many access to information laws that can be used to access the data that, for instance, our partner in Brazil, which is Internet Lab, having issued FOIA requests to get the data of the number of wiretaps, and they were able to get the data by asking to the government the information, and the same happened in El Salvador. And there are many laws, many Freedom of Information Act laws in Latin America that can be used for transparency.
So maybe Katisa, we can move to some of the work that you mentioned that some of the partners of EFF and Access
just to finish, because I should have started with this. We start just this project having done with 13 organizations, Hiperderecho from Peru, Internet Lab from Brazil, Red en Defensa de los Derechos Digitales in Mexico, Fundación Carisma, and TEDIC in Paraguay, and I may forget a few ones. And then my colleague, Luciana from Fundación Acceso, they have done their own research. They called me to work with them and advise them, so the methodology is similar, and that's why we
office in Costa Rica. I apologize in advance because it's the first time that I speak in English in public, so I'm going to try to do my best, and you can ask me all the questions if you don't understand me, and my co-panels are going to help me, I assume. Okay. Fundación Acceso was founded in 1992, and since 2007, we work with human rights defenders at risk, and we work with them in processes related with their digital security. How do we do that? Through technical assistance, workshops, and ICT resources. During those processes, the participants, the human rights defenders, ask us a lot of questions. They have a lot of legal concerns related with their digital security. They ask us, for example, in my country, is it legal to encrypt my emails? And we couldn't answer those questions because we are not lawyers. They are El Salvador, Guatemala, Honduras, and Nicaragua. Yes? I'm clear. Okay. The primary objective of the research is to analyze the legal frameworks in El Salvador, Guatemala, Honduras, and Nicaragua related to the right to digital privacy in order to determine if they can be used to criminalize and or surveil human rights defenders in those countries. Why? Because in those countries, the human rights defenders are under particular risk and they need a lot of help in their security, in their holistic security. We are talking about physical security, psychosocial security, legal security, institutional security, and digital security. And that's in the exactly the dimension where we help them. I don't know, Amos, if I talk now about the results of the research.
Yeah, maybe you can give us an overview.
Okay.
Yeah.
Okay, we found that the right to privacy has two dimensions, one positive and one negative. In the positive dimension, all people have the right to privacy. And in its negative dimension, we find the interference in private life communications, document, and people's home is forbidden. So we found that the constitution of the 4 countries have the right to privacy. In Guatemala case, this is just in this negative sphere, right? But the legal framework related to digital privacy is not only in the Constitution. It includes other laws, jurisprudence, and so on. There are many laws that address the right to digital privacy somehow, and there are 4 specific legal instruments present in some way in each of 4 countries that address surveillance or privacy issues. They are the Criminal Code, the Code of Criminal Procedure, the Law of Access to Public Information, and telecommunications laws. All these legal instruments have at least one article related to privacy. Beyond this common legislation, each country have specific laws. For example, in Guatemala, we found the Anti-Organized Crime Law and the Department of Civil Intelligence Law. And in Salvador and in Honduras are the most interesting cases because they have specific laws. They have the law of intervention of communications. We can do a whole research about this law, but how it's a comparative study, we shall treat it in generally. Also, in all countries, there are 2 fundamental mechanisms of access to justice in the context of surveillance for violation of fundamental rights, the remedy of amparo, and the action of unconstitutionality. In Honduras and in Nicaragua, we also found the habeas data. And then with Cottage, we asked how all these national laws integrating international standards. And as a standard, we use the 13 principles. Okay, and in each country, the international standards are respected to a different degree, but none of them incorporated all of the standards. Then if you have question about that, Cottage can profundize. And about the methodology, do I speak now or do I look for later?
Maybe we can hear from Dennis first, and then when questions about the methodology comes up. So Dennis, how does your research with the Internet Lab comes into play when we try to determine what are some of the trends, particularly in Latin America, on how governments are conducting surveillance?
Great. So hi, everyone. My name is Dennis Antoniali. I am the Executive Director of Internet Lab, which is a think tank in Internet law and policy in Brazil. we did the surveillance report in partnership with EFF. And the methodology was pretty much straightforward. As Kachisa mentioned, our goal was to make an assessment of the level of compliance to the international principles. So what we did in order to do that was a comprehensive overview of the surveillance laws in Brazil. In order to do that, we took like a broad concept of surveillance and analyzed any laws regarding like any sorts of access to users' data or data retention laws or anything that had to do with communications. That also means that we had to dig deep and not only look at the laws, but also at administrative rules and resolutions, and specifically in the Brazilian case, in the Brazilian telecom regulator, Anatel. And it was really interesting to see that many of the relevant laws and rules were actually there, so not prescribed by law. And that was an interesting finding already of our report. In that regard, we could say that some of the laws that we have in Brazil are reasonable, they are good, they put some good protections forward, and the problem really is in practice and the way they've been applied. For instance, one of the things that we noticed is that theoretically our wiretap law requires a warrant for accessing phone records, but there are some loopholes, and those loopholes have been exploited by law enforcement, so law enforcement can have warrantless access to phone records and because of those loopholes. So it's a matter of how the law has been interpreted. Also, what we noticed is a difference in the way that different kinds of information are regulated and protected. Account information is granted a very low level of protection, and that even in the wiretap law and also in Marco Civil, account information can be accessed by law enforcement without a court order. That is very problematic. So that was very important for us, the different levels of protections. So account information, and then metadata, there is no specific regulation on metadata, which makes it very hard and problematic, because metadata can tell geolocalization information, and if that's not regulated, it also becomes a problem, because law enforcement usually make those requests, and in the lack of regulation, those might just be granted. So that's also something that Brazil has to work on. And of course, the actual content of communication is protected in our constitution and also in other laws. And it's the highest, let's say, the highest kind of information that is protected. But also, again, in practice, we see that protection is not always fully effective. Another thing that I would like to comment on was our use of a FOIA request to get numbers on wiretaps. So luckily, we were able to, through a FOIA request, get numbers on wiretaps of landlines, mobile lines, emails, and even VoIP calls in Brazil. And that is because Brazilian law requires the judges to report monthly on the number of wiretaps that are currently being held. But what we found is that there is no data on the number of requests that are made, just the number of the ongoing wiretaps, and that makes it harder to say and to assess the role of the judges in granting those access. Since you don't know how many requests were made, you can't figure it out, like if the protections were actually being put forth by the judges. Another thing, there's no data about requests of access to stored information and stored communication, which is also problematic in terms of transparency. And we are trying to encourage not only companies but also administrative bodies to put out transparency reports. But if that was an obligation and was already into the system, that would make it much more, much easier. And I think those are the main findings that I wanted to comment on. And I'm here for the discussion and for questions, so I can.
So what I'm observing from the discussion so far is that the two things, right? One is that there are very woeful protections in place when we talk about substantive like collection abilities. And then at the same time, there's a huge lack of transparency about, you know, the fact that there is this huge lack of protections in the first place. So do these trends carry over into the rest of the world? Amy?
Sure. Hello, everybody. Echoing thanks for being here very late on the second day of the conference. I know you're all probably tired. So Access Now did a separate research project. Essentially, we are also one of the signatories on the necessary and proportionate principles. And last year, we set out to publish, we did publish, an implementation guide on those principles. And so what we wanted to do was figure out, in an ideal world, in the most human rights respecting country possible, how would surveillance work? And what is the right human rights respecting process that police and national security agencies would have to go to in order to still be able to get information on criminals and people who are committing bad deeds, but whilst respecting the human rights of everybody else and the human rights of the criminals, for that matter. So we published this implementation guide, and then we all looked at it because it had taken a really long time to write and asked ourselves what happens next. And we really wanted to measure what countries were doing against what we thought the ideal process was for what they could do. And so we started then immediately on this project to actually look at what countries were doing. And we partnered preliminarily with Columbia's School of International Public Affairs, the SIPA school, in order to get a lot of research done. And what we did is we chose 19 countries that were not the United States. What we didn't want to do is concentrate on what the US is doing, because a lot of people have done that. We really wanted to try to see what the rest of the world was doing. So we chose Argentina, Australia, Canada, Chile, China, France, Germany, India, Japan, Mexico, Myanmar, Nigeria, Russia, Singapore, South Korea, Syria, Turkey, the United Kingdom, and Vietnam. I think I only breathed once in there. And tried to see what laws either allow governments, give governments authority to conduct surveillance, or make surveillance easier. And so we've been trying, I think, over the last probably 6 to 8 months to work on this report. We're hoping we can get something ready to publish within the next month or so. We've kind of wheedled it down. We wanted to make something that was could use as a legal reference guide, but that people could actually also use to see what is happening in the world and what surveillance they might be subject to if they travel, or if they were just interested in kind of human rights practices in other countries. And so a few quick trends that we've identified. What we've basically done now is we have created charts about human rights documents and human rights treaties and identified what countries' governments have signed on to different treaties. We're creating lists of different laws, different regulations, different court opinions, major court opinions in each country. So there is an easy to identify list of things for each country that we looked at. And then we're doing a substantive kind of readout of what those laws say, and then what is actually happening in practice. So beyond the laws that are on the books, specifically in countries where there aren't a lot of laws on the books, how is that country violating what we think is the legality principle and necessary and proportionate activities that go outside of the written law? The trends that we've identified throughout those countries are that most countries have strong constitutions with guarantees for human rights protections. So that was the first thing. If you look at most of these countries, in fact, the only country that doesn't have a constitution that we looked at was Canada, which I found really interesting. You know, I grew up very not far away from Canada and didn't realize Canada didn't have a constitution. It does? That I would love to talk to you about that, because I just did research on it a few days ago. well, so we were clear that there were rights, and there were definitely rights guaranteed. And I would love to talk to you more afterward. But most countries have really strong rights. So you start out with, there's really strong protections for free speech, for privacy, due process for the most part, freedom of religion, freedom of expression, more generally outside of speech. And that was really good. And we thought we could end there and I'll go home and say that, the world was a human rights compliant entity. But no, that's not actually where we stopped. So despite this, countries are really kind of rapidly expanding their surveillance authorities. Since 2003, most countries have put in place or started the ball rolling on laws that would allow them to conduct more surveillance, that would give them more authority, which we thought was very interesting considering since 2013, the world has really been woken up to surveillance practices and has responded in a way to say we don't want more surveillance, and yet the trend legally is going the other direction. And that most surveillance laws have a public safety justification. When they are passed either with preventing child pornography, data retention, which is one of the things that we also saw being discussed a lot. Once one country has a data retention law in place, you start to see it pop up in a lot of other countries in very similar language. The same thing with encryption. We're seeing a lot of those laws that provide encryption mandates to allow law enforcement access to data. Those are written very similarly, and it's not because people are thinking the exact same way, it's because people are picking up the laws from other countries and importing it into their systems. Where the law is silent, human rights abuses are thriving. That was something that was definitive everywhere. If governments thought they could get away with something and they weren't prohibited from doing that, they were going ahead and doing it. And then finally, when the courts get involved, results are varied. We found really good court cases in some countries, and then in the same countries, we find really awful court cases. And it really cut both ways. We thought we would see a trend with judicial opinions, and there was no identifiable trend there. The 5 areas, and then I'll wrap up, where we saw laws being passed most frequently are data retention and encryption, which I chatted about. Location tracking is a big one that is starting to pop up. Lowering the threshold for access to metadata. So the idea that it is just metadata seems to have gone global, and it's not just something in the US anymore, it's something that other countries are considering. And data localization, and this is largely justified by US surveillance. We don't want them to get a hold of your data, so we're going to keep it in the country and, whisper, make it easier for our government to get a hold of that data. So those were the 5 topics that we saw most frequently discussed.
We advocate for surveillance reform in the countries or the regions that you have studied these trends? Do these results tell us that we should be focusing our strategies differently? And it's to all 4 of you, so maybe all of you can talk about that.
Well, one of the things that we found out in our recommendations is that actually we are learning a lot of the practices and the law and its application, and there is a lot of opportunity for strategic litigation. So we have seen that we have actually very good constitutional protections, and we are not challenging the constitutionality of the law in the courts. We have seen that even the Inter-American Court of Human Rights, which developed the international standards, and it's been in the European Court with the decision of the ECJ and the European Data Retention Directive. So that's one topic. Another topic is that we saw a lot of things that the judges are doing that is not in the books, that are practices, and that are actually harming some of our rights. For instance, and that's the case of Brazil with the notification principles. For instance, many of the countries' laws that we review, So that's not in the law, right? That's not in the law. That's something that probably we will try to.
Great. So, Luciana, do you agree that litigation is a key tactic here?
Yes, and we found another strategies because to close the process of the research, we organize a regional seminar to turn in the main results and also working on cross-regional strategies. And we identified the need to create an observatory in digital security to register the digital incidents suffered by the human rights sector. We know that there are observatories in other regions, but not in Central America. And we want that this register can be used to advocacy and litigation in different levels as United Nations, Inter-American system, and local and national levels. And Access is working on that thanks the support of Access Now and SIDA. And we hope that the results can be used for all the organizations working for digital security.
That's great. Dennis?
Yeah, I also agree that there are many opportunities for strategic litigation. One thing that I would add, and that's something that I already touched upon, is I think a big push for transparency also in those countries is needed. We really felt that we would be lucky because Brazilian law requires those judges to be reporting about those wiretaps. But when we looked at the data, it told us very little about the quality of the oversight that the judges were having over of these cases. So I think a big push for transparency and connect the surveillance agenda with the transparency one would be a good idea in those cases.
Great. Thank you. And Amy?
Yeah, so first of all, I'm going to say, you know that moment when you said something really stupid and all of a sudden you realize you said, not Canada, the United Kingdom. I could explain to you why I made that very, very bad mistake, and it's all part of how my brain seems to connect things. I'll go on the record correcting myself. It is correct in the documents, so rest assured. Also litigation, absolutely. I think that is absolutely right on. Transparency. I think from a policy perspective that we need to start working together globally much more, I think is one of the things that we've realized. Pushing, I mean, I work in Washington, D.C., so making sure like in the U.S., we are actually working in a way that is going to respect the rights of people outside the U.S., which is a conversation that happens just way too infrequently in Washington, D.C. People don't talk about how the U.S. should start respecting rights of people who are not within the country. And I think other countries should also start thinking about how to respect the rights of people globally. And I think that advocates who work in different countries in different areas, as many in this room and at this conference do, actually can come together and push on that level much more frequently. I think the necessary and proportionate principles were a great start, but also doing it every day when you're talking to lawmakers and talking to policymakers. Because if they're using their own laws to
Wiretapping law from, very old laws, and they're being applying to new surveillance technologies, but it's not being accompanied. I cannot be together with strong legal safeguards or no public discussion on whether what they're doing is right or not, and that's a real problem.
Great. So I'm just going to open it up to the floor before I get to Jamia. There is one question here on Slido, so I'm just going to make obligatory use of the Slido.com. So are you seeing in your findings interstate sharing of surveillance data being addressed in the national laws? My sense is no, but let's open it.
No, we learned very little from intelligence, although I haven't finished. I'm just finishing to process all the data we got from criminal matters. We have the data for intelligence, but I know it's half of the amount of information we have from criminal matters. But I don't have the answer right now. I haven't finished to process all the information.
Great.
The only place I'm really seeing that take place is in the new UK-US agreement that's being discussed, where they want to allow themselves to wiretap each other's citizens. And the US is looking at trying to pass a law, which it's not information sharing per se, but it's giving direct access to data. But other than that, you really don't see those things in law. In fact, in the US, I think, and Amos probably knows better than I do, we hypothesize that most of it is taking place under Executive Order 12333.
Yeah, but no guidance on how they share, except the leaked UK-Israel agreement. Yeah. Sorry, US-Israel agreement. Jamia, you had a question? I apologize if I'm mangling your name also.
Thank you. Well, I'm Jamila from the Center for Technology and Society in Brazil. First of all, congratulations for all the work that you're doing. It's very interesting to see such broad research and broad information about how this is evolving. And I think this was a need, something that we needed to do in order to find about strategies. And we are about to publish a study that compared Brazilian and German strategies legal frameworks regarding surveillance and intelligence. And just to add to what Amy was saying, that is very interesting to observe how even in these countries that have been like advocates for better laws in surveillance or international agreements in surveillance, their domestic legislation is suffering from pushbacks and things like that. Well, my question is about the role of trade agreements in pushing for these type of mechanisms. So we recently in Brazil approved the anti-terrorism law. And one of the motives, one of the reasons that was discussed or approved was because there are international agreements and international organizations that create risks, lists of countries where there is risk for business, and not having an anti-terrorism law could be a reason for being put in such a list. And this is something that we usually do not discuss much, but it would be interesting also to understand what's the role of these type of agreements in pushing for this, since we are seeing similar movements in different countries regarding. No, specifically, I forgot the name right now, but there was this business risk investments group. I have it on here. I can find the name, but that was specifically cited as a justification for an anti-terrorism law in Brazil, where we do not. It's GIFI in.
Financial Action Task Force.
Exactly. Yes, I couldn't know the name in English. Yes. So yes, well, if you have more information on that, or strategies how we could intervene in this type of things. Thank you.
So my coworker Estelle Massy in France actually works on trade agreements quite a lot. So I am not going to say anything that would infringe upon her vast knowledge on that area. The one thing that I think is interesting is that, I mean, one of our findings was where there isn't a framework, that bad things are happening. So sometimes it's not necessarily a step backward to put a framework in place unless that framework is exceptionally bad. It could actually be a step forward because it could be better than the practice that's happening. And it is definitely an opportunity. However, if you see in the United Kingdom, where they're discussing the investigatory powers bill right now, their impetus for that was to bring the law up to date and to make it easier to read and to condense all of their many, many different laws into one place so people could understand it. I would argue that it didn't do that. It may have modernized it, but not in a good way. So that was definitely a step backward. But not having those things in law, we knew they were doing them before. At least now there will be a legal framework. So it's not always a bad thing, but.
So maybe we can go back to slido.com. And I think the question is about the term metadata and how it seems to be a loaded term that discounts the importance of the information. Do you see that term in the legislation as well that you've studied?
No, they describe what they are trying to collect, and sometimes they have very open clause and any other data,
Right.
that you can
Which is,
collect.
in a way,
Who
a
communicate
discount.
with, yeah.
Yeah.
All the data about the communication, IP address, connection log, etc.
Although they do use it in like conversations. Like you'll see it in like when lawmakers are defending the laws, they'll say metadata. The approach that I have grown to love is the one in the principles about protected information. It's because exactly this, metadata versus content versus protected information is any information that is not publicly available, including when you have information in the aggregate. And that means like I'm tracking your location over time. That is not necessarily publicly available, even though I can look at a tweet and know one location point. And I think that is actually, it gets to both content and metadata in a way that encompasses both. But I think I think we need a term, it's just data, it's just information by any other name.
And one thing that we found is that it's actually confusing if you start creating different levels of protection for each kind of data. In the Brazilian case, we don't use the term metadata, but what we've been seeing is that law enforcement is using that as a loophole to try to say, well, if I can get access to account information, that obviously should include metadata, or if I can get access to phone records, that also includes metadata. And then we see they're trying to squeeze all the data that they want into this definitions that are already in the law, but we don't use the term.
So, any other questions from the audience? Yes.
Streaming can't hear you.
Okay. I'm just wondering if you could walk us really quickly through what's going on with the WhatsApp thing that's happening in Brazil, or happened. Seems like security theater to me, but I don't know.
Sure. I'll try to do this briefly. What happens is, and first of all, I should say that we know very little because all these cases that led to this consequences are under seal. So what we know is what has been publicized in the media, and we don't have access to the real cases. What we learned from the media is that law enforcement was actually requesting data, and in the last case, we know that it was the content of communications. We're not sure whether the request was to wiretap future communications or access to communications that would be potentially stored in the WhatsApp servers. And then WhatsApp was alleging that it does end-to-end encryption, and then it couldn't provide those information. And then according to Brazilian law, if the device is in Brazil, Brazilian law applies. And one of the mechanisms that Marco Civil, and that even before Marco Civil judges could implement, was to demand that service either to be blocked. And so WhatsApp, there were 2 court decisions last year that demanded WhatsApp to be blocked. The first one was reversed before it was implemented. The second one was implemented and lasted for 12 hours before it was reversed. And then a couple of weeks ago, a judge actually, the Facebook's vice president was arrested in Brazil because of refusal to comply with a court order demanding data that we don't know, but it's potentially content of communications. And the basis of the arrest was that they really did a broad interpretation, and in my view, unlawful, saying that because they were refusing to give the information, they would be like collaborating with the crime. It was we have a very strong and empowering law for criminal organizations, investigations for criminal organizations, and apparently no, he used one of the provisions of that law, alleging that the executive was collaborating because of the refusal.
So just to be clear, it's not like one of these surveillance laws that you've studied that is the basis of the court order?
Yeah, like the criminal organizations law is in our study because it gives access to law enforcement to some specific data for investigations that deal with criminal organizations. And actually, that is one of the loopholes. The law doesn't say specifically that it's only for purposes of investigations dealing with organized crime. So they end up using it for investigations of any kind of crime. Yeah, that law is covered in our report. Yes.
And just to echo what I had said before about countries copying other countries' approaches, France, very soon after the WhatsApp debacle, actually introduced a law to say that we can fine or imprison executives of companies if they use encryption.
That's what I feel like they're doing. They're going to a country where they know they can kind of bulldoze it through, and then immediately all these other countries are picking up whatever happens at the least.
And in a way, it's something that I haven't seen yet, and I haven't seen it in English yet, so that's why I haven't posted it myself, is that it's getting worse. And I think that Budapest actually recently introduced a law, it hasn't passed, that wants to criminalize people, the action of downloading a end-to-end encrypted app on your phone. So the use of the app or the downloading of the app. So it's not only getting to the executives of the companies, but actually to the people using the applications.
And just on that note, today a report was released of the conclusions and findings of a commission, parliamentary commission of inquiry that was dealing with cybercrime in Brazil. And out of that report, 8 horrible laws just came out, and one of them actually gives specific powers to block applications. Another one puts IP addresses as account information and therefore grants warrantless access to law enforcement. So those are horrible laws that we are now preparing to fight, and hopefully they won't pass.
Great. Okay. So I think maybe we can address that one last question on Slido, and then about the impact of TPP on surveillance very quickly, and then we can probably wrap up. So
It was not TPP. Actually, it was another treaty on. The border.
so I think the question is about whether, what's the impact of TPP on surveillance and human rights more broadly, and if recent laws have kind of started to trend towards complying with at least what we know is the draft text of the TPP. Do we know any?
I don't follow TPP. TPP regulates, as far as I understand, data protection and consumer
Right.
privacy. And I know we were monitoring more criminal law, intelligence law.
Makes sense as
So
well, yeah.
it was out of the scope of our.
Okay. Thank you so much to all the panelists for all the information and perspectives. I think there's a lot for us to go back and think about. So thank you, and thank you all of you for participating and for pulling through to the very end. Thank you so much, and see you tomorrow.
Thank you, Amos.